Welcome. I'm Shannon Bryant, Traffic Safety Resource Prosecutor for the state of Nevada. This is part of the TSRP training video series intended for Nevada law enforcement conducting DUI traffic stops. These short training videos are intended to refresh training for in-service officers who have already completed their Category 1 training. This brief training concerns post-arrest temporary license issuances to DUI suspects in Nevada and is designed to help law enforcement officers understand their obligations in this area, and will also cover a related statute change that is new for 2021. And with that, let's get going. First, it is important to point out that we are talking about the situation when a DUI suspect has been arrested, has been informed of Nevada's implied consent law, and that suspect has either refused evidentiary testing, provided an evidentiary breath test sample that is over 0.08 BAC, or the rare circumstance where he or she provided a urine sample that showed a detectable amount of a prohibited drug or a drug for which the suspect did not have a valid physician's prescription. What then, aside from the suspect's constitutional Fourth Amendment right that may require you to seek a seizure order from a judge, what statutory right does the suspect have that pertains to driving? NRS 484C.220 has the answers. Subsection 1 provides that the investigating officer is required, when possible, to serve the defendant with a DP-45 form when the officer seizes the suspect's license during the investigation. That's the DMV Notice of Revocation form that informs a DUI suspect of the immediate revocation of his or her license. It also informs the suspect of his or her rights and obligations. Those include the requirement for an interlock device in the vehicle when the person's BAC is 0.08 or above, the right to an administrative or judicial court hearing to get the license reinstated, and the immediate seizure of that driver's license. Most law enforcement officers who have conducted several DUI investigations in the course of their career are familiar with this procedure. But wait, there is more. NRS 484C.220 does more than just revoke a suspect's license. In fact, NRS 484C.220 also provides for the issuance of a temporary driver's license to the very same DUI suspect. Indeed, the statute requires the officer to issue a DUI suspect who has had his or her license seized a temporary 7-day driver's license if he or she requests it. Again, this will apply to suspects who provide a voluntary breath sample that comes back with a BAC of 0.08 or more, suspects who refused evidentiary testing, and that does include blood or breath, or when a suspect fails to submit to an evidentiary test for any other reason other than a refusal, such as, but not limited to, necessary medical intervention. Importantly, though, the right to a temporary 7-day license does not extend to those who are already operating on a temporary license, or to someone who is not already driving with a valid driver's license. So what does this temporary license look like? Well, it looks like this. This is Section 5 off of the DP-45 form, and although very short, it constitutes all that is needed to provide the DUI arrestee his or her 7-day temporary driver's license. When the officer fills out the date and time of issuance and the date and time of expiration, which is 7 days after the issuance, and then signs the form at the bottom where indicated, the license becomes valid for the DUI suspect for that period. The person to whom it is issued must keep a copy of the DP-45 with this portion filled out in his or her possession for it to be valid during that 7-day period. If the officer does not issue the 7-day temporary driver's license, the officer must fill out the reason in the box provided in Section 5. It really is as simple as that. We do have a small but very important change for 2021 after the legislative session. A refusal to submit to a preliminary breath test is no longer grounds to seize or revoke a person's driver's license. Up until this year, NRS 484C.150 did provide that a person's driver's license would be revoked if they refused to submit to a PBT, but this provision was struck from the statute. And although this is not a change from 2021, it is important to remember that as of 2018, a driver's submission to a PBT must be consensual. Otherwise, it is a violation of that person's constitutional Fourth Amendment right against unreasonable search and seizure. The result of getting a person to submit to a PBT without first obtaining a verbal consent will be a suppression of the PBT. The fact that the PBT is not admissible in a criminal trial does not mean that it is not important in the investigation, and law enforcement must not make that assumption. For more information on that particular topic, please take a few minutes and watch the earlier TSRP training video on the use of PBTs. It is also very important not to arrest a person because he or she refuses a PBT. NRS 484C.150 only provides that a DUI suspect is to be arrested after a PBT refusal if and only if reasonable grounds otherwise exist. That means the DUI arrest, as with any arrest, must be based on the totality of the circumstances and if they amount to probable cause. So our key takeaways from this training are: officers must issue a temporary 7-day driver's license to eligible DUI suspects upon request. Refusal to submit to an evidentiary test does not impact that right to a temporary license. Current driver's license status, however, does play a role in whether a person is eligible for a temporary license. There is no temporary license if the person already has a temporary license. And logically, there is no temporary license issued if the person did not already have a valid driver's license. Lastly, and importantly, refusing to submit to a preliminary breath test is no longer a basis to seize or revoke a DUI suspect's driver's license. This concludes this training video. I'm Shannon Bryant, your Nevada Traffic Safety Resource Prosecutor. On behalf of the National Highway Traffic Safety Administration, Nevada's Office of Traffic Safety, and the Washoe County District Attorney's Office, thank you for all you do and for keeping Nevada's roadways safe.